Yeah, that's all
All
I'm
right. We're good.
All right. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to this special hearing of the Kansas Supreme Court. Today is a historic day as we hear arguments for the first time by video conferencing. Because of the COVID-19 pandemic, Kansas courts are operating under emergency orders to protect the health and safety of litigants, the general public, and our employees and judicial officers. Under those orders, courts may not conduct in-person hearings, even in the performance of an essential function, if they cannot adhere to social distancing requirements and other public health orders. Because of the number of people involved in today's hearing and for other reasons, we have decided to use this unusual method for conducting the hearing today. I want to express my gratitude to all those who have worked very hard to make today's hearing possible. Those include the clerk of the court who opened our court proceeding today and his staff, our director of technology who is helping us as we bring this to you, our public information officer who are helping with the live stream, and our many administrative, research, and other support staff that are essential to this. We also know that many of those people will be working hard today as we try to bring a quick resolution to the case as we move forward. I also want to thank the parties in counsel for adhering to the strict and very quick schedule that the court set in order to allow oral argument today on these expedited issues. So thank you also for accommodating this video conferencing format. Despite the short turnaround, counsel, I can assure you that the court has read your written arguments and we look forward to hearing in this court. Today, we are here on one such case. With that, I will call this morning's docket, which consists of a single case, the case of Governor Laura Kelly in her official capacity versus the Legislative Coordinating Council, the Kansas House of Representatives, and the Kansas Senate. Will the attorneys please state their names and the parties for whom they appear?
Madam Chief Justice, and may it please the court, Clay Britton for the petitioner, Governor Laura Kelly. Also,
Madam Chief Justice, Lula Mulligan, also appearing on behalf of the governor.
Madam Chief Justice, Brad Schlossman appearing for the Legislative Coordinating Council and the Kansas House of Representatives.
Madam Chief Justice, Edward Grime, Ed on your screen, appearing for the Kansas Senate.
Thank you, counsel. Mr. Britton, your volume was a little, if it was a little higher, I think you might be easier to hear. You can make some adjustment there. You want to say your name again and we'll test that.
okay. Not sure I know how to turn up my volume on this end, but I will speak louder.
Okay, that's better, I think. Counsel, we have allowed each side of the case 30 minutes to present your arguments. As petitioner, counsel for the governor has the opportunity to split his argument, to make some argument now and reserve some time after the other attorneys have argued. With that, Mr. Britton, you may begin your argument.
Thank you, Madam Chief Justice, and may it please the court. My name is Clay Britton, and I'm Governor Kelly's Chief Counsel. And Madam Chief Justice, I'd request 5 minutes for rebuttal.
5 minutes is reserved. Thank you.
Thank you. With the court's permission, I'll make a brief opening statement, address the court's order of last night, and then turn to the many questions the court surely has. This case is about the rule of law during an unprecedented public health emergency. President Trump has told the nation to brace for as many as 240,000 deaths from a new and deadly virus. In Kansas, over 1,000 people have become sick. People died from it yesterday. People will die from it today. And unfortunately, more will die tomorrow. We know from the CDC and our state's top doctors that the only way to fight this virus is to keep our distance from each other. That is why the governor has ordered Kansans to stay in their homes and avoid gatherings. In this time of crisis, the question before the court is whether a 7-member legislative committee has the power to overrule the governor. The answer is no. The Kansas Constitution and the Kansas Emergency Management Act strike a careful balance between executive and legislative authority during an emergency. The Emergency Management Act has been on the books for almost a half century, and it states that during an emergency, the governor can only be overruled by the legislature as a whole, acting through a concurrent resolution voted on by all 165 members of the legislature. Turning to the court's order of last night, the question it raises is whether, by the terms of the resolution at issue itself, the LCC is authorized to revoke the governor's emergency orders before the State Finance Council has acted. The answer is again, no. The resolution itself only authorizes the LCC to act after the State Finance Council has acted. That has not yet happened, so the LCC's vote is void. This is certainly an alternative ground for relief, but it does not answer the fundamental constitutional question facing this court. Can the legislature amend the Emergency Management Act through a mere resolution?
Mr. Britton, I'd like to ask a couple of questions. You focused on an issue that was troubling me. Does it cause you a problem that you had not previously made that argument?
No, Your Honor, I don't think that it does. The argument is capable of being fully addressed briefly and carefully at oral argument here. And you know, the court on its own can resolve a case on any ground that it sees fit to resolve it on. So if the court sees fit to go to the textual issue in the resolution itself, it absolutely can. And there may be reasons to do that. However, I think the most important issue and the clearest, most compelling issue for the court to answer is the constitutional question of whether—
Mr. Britton, may I ask one more textual question before you move past that? And that is that in that same provision, there is a requirement that the legislature not be in session. By resolution, the legislature has continued its session to May 8th. And there is a technical meaning to the word session as defined by our Kansas Constitution. Do you have a position as to whether or not that is the intent of the wording of this provision, that anytime up until May 8th, the legislature remains in session and the LCC has no authority to act on this matter? Or is it your view that the intent was to allow the LCC to act during this period of adjournment?
The intent of the legislature can only be divined from the language of this resolution. And Madam Chief Justice, it clearly sets out at least one condition precedent to the LCC acting, and that is that the Finance Council act. The second potential condition is that the legislature not be in session. Constitutionally speaking, the legislature is still in session until sine die. So we do have two potential textual problems there that would prevent the LCC from acting, even if we were restricted just to the text of the resolution itself. But actually, in this case, the easier question to answer really is whether the resolution violates the Kansas Emergency Management Act by unconstitutionally attempting to substitute a new system of shared authority during a time of emergency through a resolution.
Mr. Britton, I'm going to interrupt you just one more time real quick before you go on. And that is just to point out that I'm sure you know that typically we avoid a constitutional question if another issue can solve the matter. In your view, if either of these textual problems has arisen and undercut the arguments of your opponent, is there really any necessity for the court to reach a constitutional issue in this case?
Justice Breyer, there is a necessity to reach the constitutional issue. The constitutional avoidance doctrine, first of all, is discretionary. I think you used the word typically used to avoid a constitutional question. Well, these are not typical times. This is not a typical case. The people of Kansas and its leaders in government, both statewide and local, need clarity on the effect and validity of the governor's emergency orders. And we can't have that until we answer the question of whether this resolution, which purports to delegate to a 7-member committee the authority of the whole legislature, is valid. And so we can certainly win on the textual argument alone in the resolution, but that does not provide the clarity and resolve the essential conflict.
Mr. Britton, so just so I'm clear, the governor is asking this court to sidestep the textual questions that have been raised and go directly to the constitutional issue that you've argued. Is that correct?
Justice Stegall, I think maybe more specifically, the court can answer both of them.
Well, why would either of those, potentially either issue resolves the case? Why would we address both of them?
Well, one of the reasons we're here on an expedited basis in this court's original jurisdiction is that this is an urgent matter of statewide concern. That urgent.
I guess I'm just asking you, if you presume for the purpose of my question that we're only going to answer one of those two questions, I'm just asking you which of those questions that your client prefers that this court resolve the case on.
We'd prefer that the court resolve it on the constitutional conflict between what the resolution tries to do and what the law requires. But again, want to be clear that the court could grant the petition in either way.
Counsel, I'm wondering if there isn't a step before the Constitution, though. I understand the necessity argument that you're raising, in which you want to get some solid resolution to this, but can't we get you there by just looking at the two statutes, 924 and 925, and say the LCC doesn't have any role in those statutes? And that gets you to the same finality, it seems to me, without taking the extra step of the Constitution about whether, a concurrent resolution can amend a statute, which I think it clearly can't, presentment to the governor and all that kind of thing. Really, don't we just have to, I guess my question is, don't we just have to look at the statutory structure and say the LCC isn't a part of that statutory structure, so you got no business in this process?
Yes, Your Honor, you can absolutely do that. The statutory text in 924 and 925 is very clear. To sort of treat this as a simple issue of not complying with that statute works. That does work. What I think the governor is worried about is the constitutional dimension of what the legislature has tried to do through the resolution. That constitutional dimension is they've tried to amend the Emergency Management Act through a vehicle that is unconstitutional.
Counsel, as you just point out, your opponents, and I'm sure opposing counsel will make this argument, argue that they have complied with the statute. And so then doesn't that put us right back to the concurrent resolution? It just seems to me that if we reach the issues you want us to reach, we have to rule on the concurrent resolution as opposed to this just purely on the statute.
Justice Stegall, I'm sure that argument will be made again. I'm not sure how that argument escapes the plain language of the statute itself against the resolution.
Sure, I understand that you completely disagree with their position. My point's a more narrow one, which is we do have to look at the resolution to resolve that question of whether or not they've complied with the statute?
Yes, Your Honor, because we don't know about what the legislature is doing unless we look at the resolution, which expresses what they're trying to do, which is.
Before we look at the resolution specifically, can you talk a little bit about the creation of the resolution? It appears that this resolution was passed by a near unanimous vote in both the House and the Senate. It was stated that your office, the governor's office or the executive branch or the governor herself, was involved in the negotiations that created the resolution. And now you're objecting to some of the terms of the resolution. Is there, and it's kind of an acquiescence type of argument, but where do you stand with that? You were involved in the creation, apparently supported it, and now you're taking a different position as to some of its terms.
Yeah, Justice Rosen, the governor's office obviously was very interested in this resolution because it does something incredibly important, which is extend the governor's emergency declaration beyond the initial 15 days. So there was certainly some consultation on that basis. And I think if you look at the almost unanimous vote in both houses, it's because the resolution does that very important thing, which allows us to draw down millions in federal emergency relief dollars and do other essential things during this emergency. To the extent that the other side is arguing about some agreement or acquiescence, the way that the governor makes an agreement with the legislature is they pass a bill, they send it to her, and she signs it. The sort of political process that resulted in the resolution here is not really something before the court or something that courts generally delve into. Courts do look at the plain language of the words that the legislature used, and we don't have to look any further than that here.
Mr. Britton, I have a question about the genesis as well. Did the governor's office, as far as you know, have any role in the inclusion of the introductory language to Section 2 in the concurrent resolution?
As far as I know, Your Honor, and I don't know everything that may have been discussed, and of course there's no evidence of what exactly was discussed before the court. But as far as I know, no, there were a lot of drafts of this resolution, various iterations. And
okay, I listened to the entire conference committee meeting, and the only mention of that concept was just kind of an aside after the Finance Council had acted on a governor request for extension of the emergency declaration. The LLC would be empowered. Is it your legal position that that language is consistent with the Emergency Management Act and the statute that sets out the existence and power, that creates and sets out the powers of the LLC or LCC, excuse me?
Our legal position is no, it does not. The LCC doesn't have any role to play under the Emergency Management Act, whether it's ascribed one in a resolution or not. So to that extent, everything that's sort of devolved to them, delegated to them, does not comply with the act itself. And specifically, of course, in this case, what we're here to talk about is paragraph 2D, which is the paragraph that says the LCC can revoke the governor's orders. That's the thing that has actually now happened, that's provided the impetus and the standing for the governor now to seek review in this court.
That they've attempted to invoke in order to take the action that they did. The problem that we've all focused on is that the introductory language to Section 2 says that that can only happen after the Finance Council has extended the emergency declaration beyond what turns out to be May 1 in this case. And when I asked my question about consistency with statutes my colleague Justice Biles mentioned, I specifically meant that the Finance Council is mentioned in the Emergency Management Act, and what was set up in the concurring resolution matches what the Finance Council's role is under the statute, does it not?
It does.
Okay, and in the LCC enabling statute, it specifically sets out that the LCC has no control over the Finance Council.
Correct.
Thank you.
And just to further clarify, your argument is that while the action contemplated in the resolution by the Finance Council might comply with statute, everything that comes after that is unconstitutional.
Correct.
And so that brings me back to how this concurrent resolution was adopted, because if the court ends up following the trail that you've set out, we would then have to answer the question of severability. And doesn't the question of severability really implicate the process by which the resolution came to exist?
No, Your Honor, this court has been clear that the severability analysis asks what the intent of the legislature is. It does not ask about process or individual legislators' views.
We wouldn't necessarily go behind the actual words on the page, but don't we have in the record an indication just through the various legislative committee actions that this was a negotiated resolution by the fact that it was first passed as a clean version and then it went to the other body with some conditions attached, and ultimately this is the language that came out of the process. Can't we look at that?
Well, I think to look at it, you look at the language that came out of the process, not the process itself. The court has been clear that the plain language, the words the legislature uses that is the expression of the legislature's intent. So to delve into any of the political back and forth that happens with every bill that becomes a law is not something courts generally do, and there's no reason to do that here, especially when the language of the resolution itself really answers the severability analysis. There is no structural sink or swim as a whole indication in the language. There are no textual hints that the first half extending the resolution is subject to or only provided that or on the condition of.
Isn't there a presumption against severability without an express severability clause?
Your Honor, there is no requirement that there be an express severability clause.
Right, it's just a presumption though. Doesn't the presumption cut against severability as opposed to how you were arguing it, which is a presumption in favor of severability?
With respect, Your Honor, I'm not arguing a presumption in favor of severability. I'm just arguing that the language the legislature used shows that there's no reason that this isn't severable, I suppose.
If we were to disagree with that, what would happen?
If the court were to strike down the resolution as a whole, is that the question?
That's the question.
If that were to happen, we would have significant problems in terms of managing the response to this emergency. The executive orders the governor has issued under the Emergency Management Act expire on the termination of the emergency proclamation. So those would expire. We also would be unable to effectively and efficiently draw down millions in federal relief funds that are contingent on the existence of a declared emergency in the state. So there would be some significant collateral concerns and damage that would be done by that. And that really goes again to the idea that you look at the language and there's no hint that the legislature only intended the resolution or the extension of the disaster declaration to be contingent on the LCC having this specific authority. There's no
Counsel, why? Let's just assume we strike this resolution down in its entirety. Just say it's null and void. Is there anything that keeps the governor from declaring another emergency 15 minutes later?
No, Justice Biles, there isn't, but it's a significant legal problem that we would have to deal with. The relationship between the state emergency response and its ability to rely on federal emergency relief funds would be significantly called into question, if not severely undermined. And so you're right that the governor can always issue another one. She then gets another 15 days, and then we can extend it out through the mechanisms under 924. But that is not, that's not a solution without significant damage in a time of urgent public health emergency.
Give
So,
me an example of that. I mean, it's one thing to say this would be a real problem, but I don't understand why.
well, for instance, Your Honor, right now, the governor has issued a statewide stay home order that puts restrictions on how and when people can leave their homes, either to get food, to do exercise, or to perform essential functions. And we have 105 counties and many more municipalities that are doing their best to enforce and follow those terms of that order. The second that the emergency declaration expires or is not extended, that order goes away as well. And again, the governor can reissue it, but it takes time, it causes confusion. And the reason we're here today is to avoid losing time and to avoid continuing confusion. The people of Kansas need to know that they can rely on what the state government is doing in terms of its emergency response. And the status quo does not give them the ability to rely on that.
So, Mr. Britton, it strikes me that what you've just described is a significant ramping up of the stakes that we're discussing here. And I guess my question is, why put all of that at risk? Why put the entire emergency declaration of the governor at risk in this litigation?
Well, frankly, Justice Stegall, the governor's not putting that at risk. It's the respondents who have put it at risk. They're the ones who have raised the non-severability argument in their response. But more importantly,
excuse me, counsel, that's only necessary if we reach the constitutional question.
Right.
We only get to severability if we're in Constitution land. If we stay away from Constitution land, that interest is protected for you, is it not?
That is correct, Your Honor. So it's a textual resolution on a textual order on the resolution's language itself would avoid the severability analysis to be sure. We wouldn't have that problem. We would still have other problems and significant ones for purposes of the law and for compliance with the Emergency Management Act. So I think we need to be clear that the constitutional and statutory question here is one that is not resolved by that textual resolution only analysis. But you're absolutely correct that we avoid the severability analysis if that's the route that the court goes. And moving back, I suppose, and I apologize, I can't see the clock. I know one of the views on the...
You have about 2 minutes left in time.
Okay. Well, then I think I'm happy to continue answering questions, but I would just close by saying the only issue before the court here today is the validity of the LCC's action on Wednesday. The Kansas Constitution, the Kansas Emergency Management Act clearly state that action was unlawful. So the governor would ask that the court grant the relief requested in the petition and hold that LCC action was unlawful and the executive order remains in effect.
I have a quick question that you sort of alluded to, I think, there in your closing. And it has to do with turning to the religious liberty dimensions of this, both via Kansas statute and Constitution. The legislative parties have tried to raise that claim. Is it, and I think I heard you say your position is that's not before the court.
That is correct, Your Honor. The petition that we filed raises only the issue of the validity of the LCC's action.
I think the opponents argue in their filings that the purported unconstitutionality of Governor Kelly's order is a sufficient reason to dismiss the petition. Could you just respond briefly to that?
Yes, it's not a sufficient reason to dismiss the petition. The petition is not in any way dependent on the constitutionality of the executive order. Whether it's constitutional or not, the question remains, can the LCC do what it did? The LCC is not authorized to do that, and that question will not go away based on the answer to the other question that the respondents are raising.
So your view would be that if this court were to rule in your favor on these narrow grounds, the question of whether or not the executive order violates either statutory or constitutionally protected religious liberty interests simply goes undecided in this case.
Yes, Your Honor. And in fact, it really must go undecided in this case. Nobody before the court has raised that issue properly. No one has standing to raise that issue. So as a matter of this court's jurisdiction, we don't have a case or controversy that raises that issue for the court to decide now in the first place.
On your standing issue, is that based on contention that they lack standing in an official capacity and that we should not look to them in an individual capacity?
Correct. And Your Honor, even if we were looking to their individual capacity, I guess that some member of the legislature would have to show that they were unable to do something because of the executive order and as a result have actually suffered a concrete injury. That clearly has not happened as far as we know in terms of the petition and the answer to the petition.
Is the only check on the governor's authority in the creation of executive orders a reassembly of the legislature to weigh in and vote either yay or nay? It can't, what your position is, that just can't be delegated to the LCC. There is some check on the governor's power, isn't there?
Absolutely. The governor can be overridden by the full legislature, 165 representatives. That's what the Emergency Management Act says, and that's what the legislature should stick to. Thank you.
Are there other questions for Mr. Britton?
Not right now.
Okay, thank you, Mr. Britton. Counsel for the respondents, I don't know who plans to address the court first and what your division of time might be.
Thank you, Madam Chief Justice, and may it please the court. Brad Schlossman for the Kansas House and for the Legislative Coordinating Council. My co-counsel, Ed Grime, will address the severability issue, any RFRA issues, and then other questions that the court may have. I thought I would go ahead and start directly with the question that the court posed in the follow-up order last night, which is the genesis of the language in the concurrent resolution. Now, I will acknowledge at the outset that statutory text typically controls, and so what I'm about to describe is not necessarily emanating from Sutherland's rules of statutory construction, but I want the court to be aware of what happened. And that is that when the resolution was being drafted, I mean, you know about the history. We included that in our brief, and the parties came together and ultimately worked out a compromise. I know Justice Beyer indicated that she had listened to the transcript. Unfortunately,
I have a question real quick on that.
Sure.
Did that introductory language that we've been talking about with your opposing counsel, was it in the original House concurrent resolution before it went to the Senate?
I do not believe so, no.
Okay, so when did it show up?
So what happened is that when the revisions were, after the compromise had been worked, unfortunately, the reviser of statutes, who's fantastic, was away for about 3 weeks dealing with a family emergency. And you'll recall that this was the time when everybody was trying to skedaddle as fast as they could from the State House because of the pandemic concerns. And so the language that actually was memorialized in the concurrent resolution did not reflect everyone's understanding. I mean, there wouldn't have been a unanimous agreement. Now, I understand that statutory text controls, but the language was written so that the LCC would ultimately have the check that has been exercised right now. Now, I appreciate that there
Counsel,
is.
let me just interrupt you there with something that's puzzling me. We know what has happened, and clearly what has happened is that the LCC has met numerous times to ratify the governor's orders, and nobody until a couple days ago ever suggested that was inappropriate in any fashion.
Correct.
But now we look at the actual language of the resolution in the heat of litigation, and we see this, what you, I think, just admitted is a huge textual problem. What is a court supposed to do with that? in your view?
What ended up happening between the parties was the issue was identified. And so the governor's office and the legislative leadership and even the attorney general got together and said, gee, this is sort of a problem here, that what's in the statute doesn't really jive with what we had agreed to. And so the parties at that time were saying, look, let's just sort of agree to
Counsel,
be enforced.
you just said something that strikes me as extraordinary, and I want to stop here for a second. Did I understand you to say that all the parties, including the attorney general, put their heads together and saw the problem and just decided to ignore it?
The attorney general advised them that my understanding that this was going to be a problem, and the legislature and the governor's office said, well, let's just go forward because, we're dealing with extraordinary times here. So my understanding
You're talking about, counsel, you're talking about after passage of the concurrent resolution.
Yes, Your Honor.
So you're talking now about post actual enrollment of the concurrent resolution.
Yes, that's my understanding.
And I'm just going to cycle back to my first question. Given that extraordinary set of facts, if I presume that they're accurate, that everyone involved recognized the problem and decided to move forward regardless, what is a court supposed to do with that, with those facts from your perspective? What's your preferred jurisprudential answer to that question?
The problem here, Justice Stegall, is that when you look at the text of the concurrent resolution, the finance counsel's authority is only to extend the declaration of emergency by a total of 45 days, so 30 days beyond the initial 15. So if that right now, the concurrent resolution, the declaration was done on March 12th, which so puts that 45 days somewhere around, April 27th or so. The legislature and the concurrent resolution extended it to May 1. So there's really nothing that the finance council could do beyond April 27th.
Well, there's nothing, according to the resolution, as my reading of it, correct me if I'm wrong, the State Finance Council could extend the declaration beyond May 1.
I don't believe that's correct.
45 days. And if that's true, it looks like, according to the plain text of the resolution, that the legislature, by the language of the resolution, has given up any ability, short of reconvening, to override any executive order promulgated prior to May 1st.
Well, I would respectfully disagree with that, Your Honor, because number one, if you look at the language of paragraph 1 in the concurrent resolution, it starts off with, as described in 48-924B3. And the language of 48-924B3 specifically imposes a limit on the Finance Council's authority to extend the declaration to 30 days beyond the original 15. So again, about April 27th. So there's no way that the Finance Council would be empowered under this current emergency disaster declaration to extend it beyond April 27th. So when someone, if I think it was maybe you or someone, had said that they've significantly raised the stakes, that's exactly true here, because what they've essentially done is that in order to be able to include the problematic provision that we're sort of here arguing about in 20-18, then they're essentially, once May 1 comes, the concurrent resolution will have extended that. But the only way to get anything done beyond that date would be by under their position, by a full vote of the legislature with all 165 members.
So it sounds like your argument, which I think I understand now, is that subsect, or that section 1 that talks about the State Finance Council really is kind of nonsense, according to your date calculation, because the legislature has already extended the order to May 1st, but by statute, that May 1st deadline is actually past any potential extension that the State Finance Council could authorize.
That's exactly correct. That's exactly right.
Okay,
yeah.
So hold on, if the court agrees with that argument that we just discussed, then what do we do with that language? What's the proper resolution for this court? Do we just write that portion out of the resolution?
Well, I don't think that that would work under the severability provision, and my co-counsel will talk about that more, but really, even as an initial point, that's one of the reasons why we have said that the Legislative Coordinating Council would be in a, needs to be able to act under these extraordinary circumstances. When
I understand that's exactly your position, but I'm just trying to find a path through this text that gets you to the LCC.
Mhm.
I think in the language of the concurrent resolution, if there is the way that you would get there is in our position that the Legislative Coordinating Council would be able to act on behalf of the full legislature during a time of recess. And when
But the
And
State Finance Council hasn't done anything yet, whether it can or it can't under the, I mean, we don't have any action of the State Finance Council in front of us at this point. They haven't done anything, right?
that's correct, Justice. And
So how do you get to the LCC when Section 2 starts with following such State Finance Council action? Putting aside your point from a moment ago is that whatever action they would take under 1 would be nonsensical because they'd be extending it beyond the statutory authority. Putting that aside, it still says they have to do this before the LCC has any power.
Right, and that's why our position is that the LCC could essentially act on behalf of the full legislature. And so when the statute talks about the extensions being permitted by a concurrent resolution, then effectively the LCC would be adopting that concurrent resolution on behalf of the full legislature during this.
So in essence, if I'm understanding you right, Mr. Schlossman, you're saying forget about the concurrent resolution. Forget about it. Just go to the enabling statute for the LCC and look at its most general language about its powers and construe that. I just want to make sure I'm understanding your argument, and construe that to give the LCC the power to do what it did on Tuesday.
I think that's our primary argument. And if you do that, then sort of the emergency goes away. I mean,
Okay, now I understand.
Thank you.
And if you do that, then we have the language about that is in that statute as well as in the resolution that the council will represent the legislature when the legislature is not in session. And we have case law that is held, has applied that language and said there is no exception if the legislature is in session. So what is the definition of session? Is it the constitutional definition of the 90 days that can be extended, in which case the legislature is still in session?
I mean, that is an issue, Chief Justice, and our view is that during these extraordinary times when you've got the legislature not able to reconvene because of this pandemic emergency, that we would construe them as out of session. I understand that there is language in there about what exactly it means to be in session and out of session, but when the legislature broke off here at the end of last month, I mean, there was an expectation that they would be out of session. Anything else would be left to the LCC to act, which is normally what the process is.
What can the LCC, if we adopt that, what can the LCC do? You look at the powers entrusted with the LCC through the statute. It talks about either may adopt and amend rules applicable to the affairs of the legislature, govern the mechanics and procedure of all committee work. Those seems to be, those kind of powers seem to be more ministerial. And is there any limitation to what the LCC can do when the legislature is not in session? Can they adopt, pass laws? I mean, given the nature of the situation we're in, is there any limitation on their power at all?
The full legislature, of course, does have the authority to limit them. I mean, they are, and if you look at, I think it's 46.
Well, can the legislature just delegate all legislative power to the LCC in these circumstances?
I mean, subject to whatever, subject to the exceptions, like on appropriations, for example, in 46-1203, they don't have those authorities, but there is there is broad authority, and particularly, I think you'd want that in circumstances involving an emergency like we're dealing with here, because the fallback position then is that if they don't have the ability to act in the absence of the full legislature, then you're essentially forcing the legislature to confer unbridled discretion on the governor and eliminating any notion of checks and balances. And that's what was attempted to be avoided here.
Well, that is a policy argument that could have been taken care of simply by amending 924 and 925 to give the LCC the ability to act when the legislature's not in session. It doesn't do that. Neither one of those statutes does that. And the problem I'm having with you wanting to read a substitute hitter for the full legislature in these emergency management statutes is that if you look at other parts of Kansas law, they allow for that. In fact, this if the legislature's not in session under these laws, it's the state finance council that can take that 30-day extension. But if you look in other parts of other Kansas laws, they'll say when the legislature's not in session, X, Y, and Z can happen by the finance council, by the legislative coordinating council, sometimes by the chairman of the budget committees. But in this statute, we didn't do that. And so you're trying to read language into a statute that's not there. And while it may be a good idea, all you guys had to do was amend the law and send it to the governor for presentment, and the governor signs it or doesn't sign. I mean, you just need to amend the law. It seems to me you want a concurrent resolution to be able to alter a state law.
Well, I would say, number one, I mean, there were, I know at least one, I know the Attorney General had suggested that the statute be amended, but the legislature went the concurrent resolution route because that language is actually in 48.924. So I think they felt that at the time that there was when the LCC acts, it was going to be able to act on behalf of the full legislature because that has typically been done. And then we had this drafting issue that, has creeped up here and has caused all these issues.
Council.
Mr. Schlossman, I have a quick follow-up just because the AG's been mentioned. So you said the AG advised them to amend the statutes. That was before the conference committee met, right? Because I think that's referenced during the conference committee meeting.
I believe that is correct.
Okay. And so at the time,
we don't have any record. I mean, so we're dealing with an original action, but that's my understanding of the factual background.
All we have to rely on is what they said they've done when we listen to them on tape. I mean, that's what we've got. Okay, so admitting the frailty of that record, are you telling us that at the time the AG issued his guidance, both the early guidance, which I think was March 24, and then the later guidance to law enforcement, that he was aware that this drafting snafu exists with a concurrent resolution?
I don't know what he knew at the time. I wouldn't have.
You earlier represented to us that he was part of the discussions post passage of the resolution.
Right, post passage.
Well, that's what I'm talking about. His guidance to the passage of the resolution was March
12th.
The conference committee report was adopted by the House and Senate on March 19. His first issuance of guidance to the law enforcement was March 24. And I believe is the date on it. And then he issued another one last week. Are you suggesting that somewhere between the passage of the statute and the issuance of that first or second guidance, he was engaged in discussions with legislative representatives and the governor's representatives to just essentially say, we know this is all messed up, but we're going to behave as though it's not?
Oh, I don't think that the AG did anything like that. I'm saying that the governor's office and the legislature made that assessment. I mean, the AG doesn't have any authority to tell them, what to do or not to do. So
I thought you said he was involved in that discussion, or his office was.
My understanding is that he that they had consulted him and he identified the problem. I don't have any sense that he made any recommendations on that.
Okay, thank you.
Identifying a legal issue.
All of that, with all of that history in mind, we still have the fundamental problem that a basic rule is that courts do not strike language, add language, rewrite language. We just don't write the statutes for the legislature. So where are we? Even if we have enormous sympathy for the practical reality of what would result with having to bring the legislature back to session.
With that question, I think that's a nice segue, if I can, to throw it to my co-counsel at this point, who is prepared to address those issues, if that's okay with Your Honor.
Okay,
I have one quick follow-up, if I may, for Mr. Schlossman.
sure, certainly.
It strikes me that what I hear as an undercurrent to all your argument is that the type of power being exercised by the governor under the Emergency Preparedness Act is actually legislative power, and that given that, courts should broadly and liberally construe the legislature's ability to oversee the use of that power.
Yes,
Is that a theme that runs through your arguments?
I think you could say so, yes.
And are you arguing that that principle of equity should guide our or alter our typical statutory construction and interpretation rules?
I am in this context, particularly in the context of an emergency disaster where the legislature's ability to reconvene and act in a broader sense is severely limited, like it is right now. So,
Thank you.
thank you. So with
But you
that-
haven't made an equitable estoppel argument just based on these discussions, have you?
No, Your Honor.
Thank you.
Any other questions before Mr. Grimes starts? Mr. Grimes?
Thank you. May it please the court. I will just focus on severability, but I recognize that we may have questions right up off the bat here. One thing I want to mention right away is that, the question of oversight runs throughout the statute, the emergency management statute, but it also runs throughout this resolution, this concurrent resolution. And I would start just with the textual argument here. In fact, if you look at a printout of this, I'm not going to try that. If you look at a printout of the concurrent resolution, you'll see that most of the text concerns itself. There you go. You've got it. Most of the text concerns itself with the question of oversight. And in fact, the question, and I'll connect this up in a moment, but the question of what the LCC can do doesn't only appear in 2D. In fact, the revocation power also appears up in 2A. It's mentioned twice. And then there's a dense tangle of text about exactly how they are to meet, and then which types of orders they're to review. There's a great deal of effort spent here on this. And so I think that textually, the court can say that this resolution rises or falls on the question of does the legislature get to keep the oversight that it tried to give itself here? It tried to give itself the same oversight that it has in the statute, but it tried to modify that for an emergency where the legislature itself can't even get together in Topeka.
Mr. Grimes,
Yes.
I think I understand the argument about what happens in the resolution textually between 2A and the end of the resolution. That makes sense to me, and I think you described it accurately. I'm going to ask you the same question I asked your co-counsel. Can you help us, or can you chart out a path textually through the language of the resolution that gets us to 2A under these facts?
Well, I think as of right now, if we are stuck with the language of the resolution, I don't believe the resolution can get us there. But let me raise an important point about why we want to reach beyond that. And it's the relief sought and the pleading of the state. the governor that brought us here. They are
Council,
not,
I'm sorry, there's
Audio
poor
problem.
quality. If you could repeat what you just said, I got I think I heard that you say that we are stuck with the text of the resolution, but I had difficulty understanding after that point.
very well.
That's better. Thank you.
Much better.
All right. We're stuck with the pleading here, and which has just been reiterated, I think, by the governor's office. They are not asking just for a decision about this executive order. Their relief sought, point A and C, wants to enjoin the LCC from taking any future action. And in fact, what you've heard from the governor's office today is that they seem to think the SFC may spring up again, and that they could somehow come into play and extend this another 30 days. The problem, as my colleague pointed out, though, is that if you look at the statute, that's a one-time card, and it's not just a get-out-of-jail-free card like in Monopoly. And when you don't want to pay $50, you take it out at that time. It's got to be used right away, or if not used right away after the 15 days. After 30 days after the 15 days, you're all done. So the SFC, if it's not already out of the picture, is about to be.
So
Nonetheless,
counsel, I'm sorry to interrupt, but I just want to bring clarity in my own mind, at least. It sounds like your argument is that even if this court were to find, based on the plain language of the resolution, that there is no path for the LCC to act, that the consequence of that ruling would be that under the plain text as interpreted by this court, the emergency declaration would end on May 1st, no matter what.
correct. The emergency. So here's the situation we're now faced with, Judge Stegall, and we're faced with May 1 is going to be the drop dead date, no matter what. Okay, no matter what. But actually, the severability analysis that I was going to address would show us that if the LCC doesn't have authority, if it was improper to insert them into the resolution, then the resolution goes away. And I know the governor's office made lots of statements about the loss of federal funding. There's no record evidence about any of that. But I think the path forward from that spot would be the governor does declare emergency, a state of emergency all over again, gets 15 days, and then the legislature may well have to come back and they'll get a second bite at the apple with the benefit of everything we talked about. The governor won't be starting from scratch. We've just done this 3 weeks ago. You've got all these orders. These executive orders can be entered almost immediately. And so I guess my point for the court is that scenario is really not very different from the status quo, which is going through to May 1st. And so that actually may get us out of the legal thicket that we're in. It may give the legislature a chance to come back in and address some of these issues.
Counsel,
Yeah.
excuse me, counsel. I'm sorry to interrupt, but it's hard in this format not to just start talking. Sorry about that. I'm a little confused by the point you just made. It sounds to me like you're saying that it's, first of all, it's not severable. That's the position your side of the case has taken. So if we reach the constitutional question and we say it's not severable, then everything just starts over. Is that right?
Correct.
And at that point, the legislature would have another opportunity to do this, for lack of a better word, right, get the wording of the legislation correct, or amend the 2 statutes that Justice Biles has made reference to, that sort of thing. Is that what you're advocating for? Did I hear you?
Yes, well, Your Honor, I don't want to go too far down the road and speak for the full legislature. What I would say is this, though. Unquestionably, if the LCC portion of the resolution can't be in there, then the mechanism for control has failed. It has failed. And so we have to strike it down. The governor could step in right away. And then at that point, we've got 15 days. That will give the legislature a chance. Can everyone hear me?
Yes, but let me ask my question now. I think I understand your position being not severable. You have to reach the constitutional claim raised by the governor. And once you do, the whole concurrent resolution goes away, correct? Those are your dots to connect.
Well, Ryan, of course, we believe that, that there's this other argument about the mistake that was made. But
sure.
Right.
But if the court disagrees with that, those are the dots that you're connecting. And my question goes specifically to that first dot. Are you taking the position that this court, the position that would essentially be in agreement with what we heard from Mr. Britton, that because of the way the pleadings are styled, that we're stuck with those pleadings and we have to reach the constitutional issue that was brought to this court in the first place by the governor? Is that your view?
Well, let me put it this way. The governor has already, the governor challenges the use of the LCC altogether, right? And so even if other things happen that haven't happened yet, like the SFC acts, we're going to be right back where we were before.
So it sounds like your answer to the question is yes, you think that because of the way the pleadings are styled, we have to reach the constitutional issue presented by the governor's office.
Well, not only because of the way the pleadings are styled, but we can just look at what's happening here. I mean, if we have a narrow decision and say, well, the LCC couldn't act even under the resolution, so this particular act is gone. Come back to us again in a few days when new things happen. We're going to be right back here all over again. I mean, here we are rushing around right before Easter on the theory that people will come to church and spread the disease on Easter. This should never happen this way, frankly. What we really ought to do is have something that gives us a fresh start. I think we do have to go on and reach the issue about whether this resolution can survive.
I think we fully grasped the practical need, but I think what we've been trying to drive at the whole argument is the legal path.
Right.
And we just do not reach out for constitutional issues when there are other ways of resolving cases, and we don't make public policy.
Absolutely, and I
try to avoid it at all costs. So
right, I think I have an answer. So if you go to a plain text review of the resolution, you'll see that even if the LCC can't act right now, even in this mistaken text, the LCC will be able to act soon. The governor has mentioned in its filings that it believes the SFC can still act, that that's still valid. And so what we could quickly see happening is the governor going to the SFC, and then the SFC acting. Now the LCC, even on the mistaken terms of this resolution, which don't reflect the agreement, would have the authority to act. And so we all recognize that, and the governor has pled that this is a case in controversy, and they're seeking relief on those grounds.
I had understood you, actually, I think it was Mr. Schlossman made the argument. Do you agree with his argument that the State Finance Council cannot act here because of the way the dates fall?
Yeah, I've got a bit of a nuanced position. That's exactly right, because the statute says 30 days beyond the initial 15. And so, but remember, there's actually still time. There's actually still time for the SFC to act, although it may not be in a position where it can extend it a full 30 days. I don't think we quite know the answer to the question of what happened.
Just let me ask the date question.
Right.
The way I read the dates, 30 days past the initial 15 falls prior to May 1.
Correct.
And so the furthest out date is actually the date approved by the full legislature in HCR 5025.
Right.
Wouldn't that trump any purported action by the State Finance Council?
It would, but it absolutely would. My point, though, is a little bit different. It's that the governor might nonetheless go to the SFC, even though I agree with the statutory analysis. I don't know that they do. And so, if that were to happen, we would find ourselves back within the terms of the resolution. And so, I think there's a reason. I mean, that the governor clearly wants this decision, and I think we need to reach it. I think we need to reach it. I think, unfortunately, the problem is that because of severability, the entire thing falls out. But that's not the end of the world here. It's not the end of the world that the governor suggests.
Council,
What's to prevent the legislature from fixing the problems between now and May 1st?
Well, the only thing that prevents them is, I mean, remember, we're in this position for a reason, which is that the governor urged everyone to leave Topeka and to get out of town because of the coronavirus. I mean, there are real issues with convening a legislature, and so that's the number one issue. There's no legal impediment, but there's a practical impediment that they tried to account for in the resolution after discussions with the governor. And in fact, they and the governor have been proceeding on those grounds up until just a few days ago. I want to raise one other quick point that I think is important on severability. And it's this idea that you cannot look at the surrounding circumstances and you can't look at subjective intentions. I think this is a place where the record that we have about the parties' discussions does become relevant. Because in the Gannon case, the school financing case, this court expressly quoted statements of legislators. I'm sorry, I think I'm shuffling paper and it's covering me up. But in the Gannon case, the court quoted at pages 1201 to 1202 statements made on the floor of the Senate by different senators about the hold harmless provision. And that was a factor for this court just 2 years ago, or 4 years ago, under prong 1 of its severability analysis. So I believe that here, a lot of the factual record we've discussed goes to the question of what did the legislature intend, what were its negotiations with the governor in drafting this resolution, and then what should happen if one of the essential pillars of this resolution falls away.
Council, everyone's been talking about this May 1st date, which gets me to some of the issues with this resolution, but it also gets me to that. Where does it say in the statutes that the legislature can condition its ratification on a date or on anything else? I mean, the word ratification has got a meaning in the law, and I mean, you just have to open Black's Law Dictionary and there it is, and it's an up or down deal. And it seems like the statute, to do what all of this is about, would need to say ratify or impose other conditions or something by concurrent resolution, something like that. But it's an up or down vote by the full body of the legislature. And that's the way, when these statutes were promulgated and enacted, that's the way they resolved the oversight issue. And so, again, I guess this gets down to the definition of what ratify means, but how do you put conditions on this stuff, especially the first date?
Your Honor, I don't know that the definition of ratification ultimately resolves the question. I think the real issue is, do we have to assume that what is stated in 48.924 is exclusive? And so if it doesn't, nowhere does it say only, solely, exclusively. Nowhere does it use those words that usually tell us that this is the only thing you can do. I would note that if you look at the resolution, there are other portions in there. There are other things in there. The firearms issue, for example, that the governor seems to have no issue with. That is an express. It says, for purposes of this ratification, the governor shall not have the power or authority, and then it goes on. The other important thing is, ratification is often something that happens afterwards. And a power that is very close to ratification is going in and just flat out revoking something that's happened. And so here, the legislature already has the power to revoke specific actions that the governor has taken. Nobody is disputing that in this case. And so surely, if you can revoke specific actions that the governor has taken, you can say, all right, I'm going to ratify what you've done so far, and come in advance of the specific actions and say, certain things are going to be carved out of your power, or certain things are going to be added, to our authority here because we can't be in Topeka. And without that, the statute won't work. There will be no oversight.
Counsel, you're out of time, but I want to not let you go without asking you about the religious liberty dimensions of this case, both statutory and constitutional.
Yeah.
Do you agree with the governor's office that those issues are not truly joined in this case and before this court?
What I would say is this, that it is true that the legislature does not have standing as a party that has been injured as an institution or that has its own religious liberties being infringed. However, the reason it was that those issues were raised here, number one, that is what motivated the legislature's action. I think that's in the record now. And number two, our argument has actually been that any relief for the governor here would be futile because the only change that was made in this most recent executive order was what we have said is a targeting towards religious institutions. We've said that is unconstitutional. And so if the relief that the governor is seeking is to achieve this unconstitutional end, it would really be futile. But that is our only argument, Justice Stegall, and I would agree that we don't have standing to raise a claim under our authority.
You would further agree that even if this court were to rule ultimately on whatever grounds in favor of the governor, that would not resolve any constitutional or statutory question of religious liberty. That issue would have to be brought in a new action by somebody.
Absolutely. Yeah, there's absolutely no question. Someone else would have standing and injury and would be able to come in. And
so that kind of resolution of the case would just leave those questions completely unanswered.
It would.
Are there other questions for Mr.
No,
Ross?
that was what I was going to ask about.
Okay. Thank you, counsel.
Thank you.
Mr. Britton, you reserve 5 minutes.
Thank you, Madam Chief Justice. I want to start with something that Mr. Grime mentioned. He said what we ought to do. The issue for this court is not what we ought to do, but what the law is. So we start there. Let's talk
What if we have a circumstance that council raises that prevents the legislature from reconvening? What happens then in this kind of interim situation? Is the governor just, or any governor just have the ultimate authority in this if the legislature can't reconvene? Is there any delegation of authority? Is there any mechanism to do anything about that?
Your Honor, no, there isn't under the law. Under the Emergency Management Act as written, the check on the governor's authority is to be exercised by the legislature as a whole. So they need to meet in some capacity. Now, they don't have to, I'm unaware of a requirement that they be in the same room, that they not be able to use online means like we are doing here today. South Dakota did it recently with their legislature. So there are certainly options for them to do that. And I also want to make clear that we have, that the governor has no objection to the Emergency Management Act's a sharing of executive or of emergency authority. The legislature has an oversight role in all of this. That oversight role is set out by statute, and the legislature, like the governor in this case, needs to follow that statute.
Mr. Britton, do you agree that the powers being exercised by the governor under the Emergency Preparedness Act are legislative powers delegated to the governor, delegated to the executive branch during a time of emergency?
Justice Stiegel, I'm not sure I can agree with that. I think that's a big question, whether these are legislative powers or some conditions on executive powers. I don't think that that issue is directly before the court, and I don't think it's necessary to resolve it here.
You think it makes a difference. You disagree with your opposing counsel's argument that it makes a difference in how strictly or liberally we apply our interpretive principles.
Correct. Whatever interpretive principle you apply, it's going to start and end with the plain language of the emergency.
Let me just ask my quick follow-up on that. We often hear, and there's a pretty robust school of legal thought, that in extraordinary times of emergency, such as we are in right now, all branches of government ought to be afforded relief from some of the legal formalities that we would observe in every other situation, so that government can effectively address the practical realities of the emergency in front of it. Oftentimes this happens in wartime. Do you think that we're in a situation now when this court could relax its traditional interpretive rules in order to get underneath to the practical realities of the situation we face?
No, Justice Stiegel, I don't. The law is the law, and it can work perfectly fine in this situation. In fact, the Kansas Emergency Management Act is designed specifically for situations where you may need to relax some of the normal rules by which we operate our government or govern our citizens. That's built into the act, and you do that through an executive order that exercises the power under that act and the governor's executive authority. So we don't need to look beyond the law. We don't need to do anything special other than what this court does in every case, which is read the law, interpret it, and apply it here. And if the court does that, I think the answer is clear. I do just want to mention this court's case in 1998 of LCC versus Stanley in terms of the LCC's authority to act. The court said there the LCC is an administrative agency created by statute. Its power and authority are defined by law. The LCC statute may say that it can represent, quote unquote, the legislature when it's out of session, but that no more gives the LCC the ability to represent the full authority, the policymaking authority of the legislature, than I, as a representative of the governor here today, can exercise her full lawmaking or executive authority. Finally, I just want to say this is a time of unprecedented crisis and danger. Lives are on the line, clearly. Every day counts, every minute counts. The governor has asked this court to act quickly to resolve this pressing legal issue. I appreciate the court's time and quick turnaround on this, and we would ask that the court grant the petition's request for relief and hold the LCC's vote was unlawful. Thank you.
Any other questions of counsel? Thank you, counsel, for all of you for your arguments. The court will now take this case under advisement. I would let you know that we do plan to begin conferencing in just a few minutes as we conclude this video conference of arguments. We will plan to work expeditiously and to attempt to present a decision as quickly as we can. With that, we will try to stay in touch with counsel to advise them of progress if we are able to make an announcement today. Again, thank you to everyone involved in today's proceedings. This has been an unusual format for us, but I think everyone has adapted well, and I appreciate that. Court is now adjourned.